So what is a right of survivorship? Well, folks, a right of survivorship generally applies to a jointly held asset. Could be a bank account, could be real estate. And in a right of survivorship, the surviving owner absorbs or receives title from other owners who pass away by operational law with no judge necessary. Now, we see a right of survivorship in certain assets like bank accounts. With a bank account or with another type of an account, you might see TOD, which is transfer on death. And so the individual's named on the account. If one individual dies, the other individual's named on the account and they receive the rights to that account. Another way to see this would be POD, which is payment on death. This typically applies to bank accounts. And once again, you'll have a few named, maybe two named or three named individuals on an account. One passes away and payment on death to the others, the survivors. By operational law, no judge necessary, no probate court necessary. Now, in my practice, where I see the right of survivorship is when we talk about title to real estate and how we phrase a concurrent tenancy, which is basically title of a piece of real estate that is held in the name of more than one person. Now, when it comes to concurrent tenancies, the first that we can think of would be a tenancy in common. Now, with a tenancy in common, there is more than one person on title, and they all hold a proportionate interest in the real estate. If one person passes away, then their interest goes down their bloodline or goes into probate. There is no right of survivorship with a tenancy in common, so it doesn't go to the survivors on title. Another facet of a tenancy in common is that the title owners can sell their interests. So if there's three title owners, 1/3 interest could be sold to another individual freely without the others joining in on the deed. Another concurrent tenancy with a right of survivorship is a joint tenancy. Now, with a joint tenancy, there's more than one person on title, and the surviving owner would absorb title of any other owner that passes away by operational law, no judge necessary, no probate court necessary. With a joint tenancy, the parties are typically not married. They can be, but they're not married. They can be brother and sister. They can be relatives. They can be friends. But there's still a right of survivorship there. With a joint tenancy, let's give an example. If there are two people on title and one decides to sell their interest to another party, they can. But what happens to a joint tenancy when an interest is sold is the joint tenancy, the right of survivorship, is terminated. It's severed. And the result of the tenancy with the new person is a tenancy in common, where remember, there's no right of survivorship. Now, another concurrent tenancy that I see often is a tenancy by the entirety. And with a tenancy by the entirety, the couple must be married. In Massachusetts, a married couple is considered one. And there is a right of survivorship there. So once again, the surviving owner would absorb title from the other owner that passes away, the other spouse that passes away. By operational law, no judge necessary. Now, with a tenancy by the entirety, it's a little bit different. It's a little bit more difficult to sever, to break. You can only break a tenancy by the entirety by death, divorce, or agreement. One of the parties dies, the other receives title, no more tenancy by the entirety. Divorce severs the tenancy by the entirety. So the spouses or the ex-spouses can be on title still, but they'll hold title as tenants in common with no right of survivorship in that instance. The third way to break a tenancy by the entirety is by agreement. And so the parties to the deed cannot freely sell their interest, the 50% interest in the real estate. You need both parties to sign the deed in order for a transfer to be valid. Where else do we see a right of survivorship, even though it really isn't spelled out in the title? Well, when we talk about life estates, and I've done previous videos on all of these things, which you can see below inside the description. But back to life estates. Typically what happens with title at that point is more than one person is on title. It's a concurrent tenancy. And one owner of the property has the present interest in the real estate to live there, to pay the bills, to do everything as far as maintenance of the property and preserving the property for their lifetime. Upon their passing, it goes to the other individuals named on title, called a remainderman. And there is a right of survivorship there. It happens by operation of law. The remaindermen, the folks that are on title waiting for the life tenant to pass away, have a future interest in the real estate. The life tenant has a present interest in the real estate. And as far as severing a life estate, you need all parties to join. While the remainder men can sell their interests to other individuals or transfer their interests to other individuals, they cannot terminate the life estate without everybody joining on the deed. So this is the way we typically deal with rights of survivorship. You can also have beneficial interests in things like trusts or investments where folks are named as beneficiaries. A little bit different from a right of survivorship. So once again, please make sure that you check out the links in my description below. Make sure you subscribe in the lower right-hand corner to my channel. And there'll be other videos appearing here, lists of videos for real estate and other related videos. Make sure you check those out. Dave Ceruolo, CeruoloLaw.com.